What is one simple strategy that can dramatically reduce estate taxes if implemented early enough?
Setting up separate irrevocable gifting trusts for your kids and let them be the initial investors in your new business that you're creating.
It's my pleasure today to welcome everyone to our Counting Capital podcast at Buchanan Street. I'm Robert Brunswick, the chairman of Buchanan Street, and I'm very excited today to have Anson Cain with me, a partner at Albrecht Barney, a very well-known legal firm that specializes in estate planning. Interestingly, I've often been asked by a number of our viewers and clients to maybe have an episode or have an expert, a resource that we could talk to provide some insight, especially in this day and age, to the estate planning as it really pertains to wealth succession, gifting, philanthropy, and needed income tax planning. So I think you'll find Anson to be a great resource. Our family uses Anson in his firm. We've thoroughly enjoyed building a relationship with him, and as you'll see, his ability to really educate and help customers understand the complexities of that space has been something that we've enjoyed. Not surprising that he has that acumen, as he also serves as an adjunct professor of law, teaching estate and trust at Western State College of Law. So other things, just so you can get to know him briefly, very well-rounded guy, likes adventure, was an All-American athlete as a soccer player, held the presidency of the Student Accounting Society. So he knows the tax side of this, which is very important. He was published in an ultimate editor-in-chief of the National Association of Administrative Law Judiciary, and he received varying degrees from Point Loma Nazarene, Pepperdine School of Law, with a special added degree in estate planning from Miami School of Law. So Anson, great to have you on the podcast. I know this will be fun, and looking forward to sharing your wealth of knowledge and experience with our listener base. So
thank you, Robert. Happy to be here.
Maybe we can get started with supplementing what I just shared, a little bit about your background growing up as a kid. How did you choose this profession?
Sure. So my family's a little unique. I'm actually an Arizona kid. So I grew up in Arizona. My parents are actually celebrating their 50th anniversary today, which is always a nice achievement. But I'm one of four children. All four of us are attorneys, different areas of law, but all attorneys, which makes the holidays very fun. But I found my way into this area of law by going to undergrad and doing double majoring in business and accounting. I went to law school thinking I was going to become a tax attorney, saying that is my path, that is my drive, that is what I'm going to do. So I took every tax course possible in law school. But then I took a wills and trust class. And then it was just that perfect moment where I realized I can actually interact with people. I can engage with people. I can help people. And each person and their family and their tax situation is its own puzzle that through the tax code, you can provide a lot of benefits. And so that was just the perfect situation. And from there, the rest was history. And I drove every decision, everything that I did to become the best estate planning attorney that I could. And that's why I then went to Miami to get an LLM in estate planning as well.
Well, I'm not objective, of course, because we work together, but I would say that you've accomplished what you set out to do, and you're still at an early stage in your career, so a lot more to take on. I'm amazed with just interaction with our clients, friends, people of great affluence, and certainly with sophisticated with meaningful wealth, how ill-prepared or unprepared they are in thinking through that estate going forward. And so you and I have talked a little bit about that. So maybe first of all, describe really Albrecht and Barney's practice and your specific area of expertise. You kind of touched upon it, but
so what's unique about our firm is we've been around for over 30 years, and we have 10 attorneys, and all we do is estate planning. So it's estate planning, trust administration, probate, charitable planning, advanced planning. If it's in the world of estate and gift planning, that's what we do. And obviously there's a touch of business succession planning there as well. My practice is a little more unique because of my background, I spend a lot of time dealing with more tax sensitive planning, whether it's income tax planning or property tax planning or the standard estate and gift tax planning. I have my hands in all of that, and I'm providing options and opportunities for these clients to be informed and find out that there's some better options out there.
Sure. So I remember you and I have talked about this. My wife would say, "Well, why are you adding all these complexities to our life with all these documents and entities and whatnot?" So this advanced planning doesn't come without some cumbersome structure and documents. Can you color that a little bit?
Everyone kind of needs the fundamental estate plan, the basic will, the basic trust, the basic power of attorney, basic healthcare directive. And that really is your core documents. But on top of that, you can do other things. Whether those things are motivated based on asset protection or income tax planning or charitable planning or estate and gift tax planning, there are many different trust tools out there that accomplish different goals, kind of driven by what are you trying to accomplish and what assets are we working with? Because both of those factors really drive how we design the advanced planning. And so it can be advanced planning done in California, or sometimes we even go out of state and do out of state planning.
So as people think about, you got your block and tackle, you got your will, you've got your rev trust and whatnot. But as people think about um, coming to you and seeking your counsel, if you were to give them three questions that they should think about, or several questions, um, what might those be before they get to you that is going to help you then determine what customization estate plan they ought to think about?
I think there's three things. One is generally, where do you want your assets to go? And that's a big decision. Sometimes for some families it's simple, and it's I want everything to go to my kids. Or other people are really involved in philanthropy, and they say I want to leave something to this charity. Well, that's great. They have a general idea, and then through our conversation, we'll nail that down, and we'll get a little more specific. We'll put in more tools, more options, more flexibility, depending on what their goal is. So knowing generally where you want your assets to go is the first key. The second big key is understanding, well, who do I want to have in control when I no longer can be? And kind of thinking through that. And so that is a big decision, and I can help flesh that out and provide other options besides your normal family members. But thinking through that's also a second big piece. And the last big piece, which is sometimes a surprising question, is having a good understanding of what your assets are and what the general value of those assets are. You'd be surprised how many clients don't know everything. They have a good understanding of part of their balance sheet, but not the whole balance sheet. And the balance sheet really does impact the advanced planning tools that are available to you and the tax consequences of what we're looking at. So having a good understanding of your basic balance sheet is important.
Well, that's a good frame as we kind of continue on. I'm thinking about all the articles you read, everything you hear about the great wealth transfer that's going to take place in the next 10 to 20 years. You hear numbers from 60, 70 trillion to 130 trillion. And I'm wondering how you think about that in your business as you prepare people, and how unprepared are people to not address this thoughtfully for the benefit of their family and that legacy.
It's surprising how many clients, for one reason or another, who just put off the estate plan, or they did the estate plan back in 1990 and they haven't looked at it since. But obviously, their world has changed, their life has changed, their assets have changed, the world has changed, but they just haven't gone back and looked at it. Why that's so surprising is, as you were just mentioning, Robert, it's about 1 in 5 people in America is 65 years or older. 1 in 5. And as they go on and live their life, those individuals will at some time pass away. And that's where you're talking about this trillions of dollars of wealth that is going to be going from that generation, that baby boomer generation, to the next generation. And with proper planning, You can mitigate estate taxes. You can avoid GST tax. You can, if you want to give these assets to charity versus giving them to the government, there are lots of things you can do that are tax advantage to you now and when you pass away if you just are proactive. And that's the key, getting proactive before it's too late.
Sure. So there's probably no exact math to this, but I'm going to assume there's a very meaningful percentage of that 70 to 130 trillion dollars of wealth transfer in the 20 years that is going to end up with the federal government. Is that a fair assumption that could have been prevented? We all paid tax going in, earning that money. We've seen it grow, and then to have to pay tax again seems like a shame when thoughtful planning could have been brought to bear. Now, again, there's a smaller percentage of people that will affect, and maybe you can just frame that segment of net worth where that starts to become an issue of federal estate tax.
It's actually really interesting about where that tax is going to be paid from. It's more likely going to be paid from by those families in the 10 million to the $500 million range. Those are probably the big chunk of where this taxes are going to be paid to the government, because a lot of the families that are above that figure of around over 500,000, 500 million, a lot of them have already been actively planning for years, for decades even. And they have started a long time ago getting assets out of their estate to avoid the estate tax. So when they think, well, these billionaires, will they be paying the estate tax? You'd be surprised how little they might actually be paying in estate taxes just due to the fact that they did planning early and they were active in it.
So you said 10 million to 500 million. That segment is the one that's going to be most disadvantaged. But as I think about what is the minimum estate tax trigger, isn't it today about $14 million per individual?
Yes. So the estate tax is really a tax on the transfer of your wealth. And the government says, we will let you, if you try to transfer your assets during your life, they impose a gift tax. If you wait until your death, they impose an estate tax. So they get you either way whenever you transfer those assets. However, they give you a credit amount and they say, we'll let you transfer up to this dollar amount this year without paying any tax. And so what that amount is in 2026 is at 15 million, less than anything you previously used. And so you can use that for either lifetime transfers this year, or if you passed away this year, to transfer assets to anyone other than a spouse or charity. That number that you're talking about today is at 15 million. And if you're a married couple, then that's 30 million because you each have a $15 million exemption. But the reason why I used the number 10 million as the real factor was because there's no guarantee that this $15 million exemption is going to be in place in the time you pass away. That number is really more like a roller coaster that is totally dependent on what's happening in Congress. So if a Democratic Congress comes in, do you really think that they're going to keep a $15 million exemption in place? Probably not. And as our bills and expenses in this, as the United States is spending more money rapidly, where are they going to get paid for? How are they going to repay those debts? Taxes. And so taxes are going to become more and more aggressive as time goes on.
Yeah, I've always thought that the federal estate, the estate tax that we will address at that stage in life is it one of the easier things for the Congress to get their arms around as they look at paying this deficit this deficit that we have, because over $30 million doesn't affect most people, and we all know about the policies that are underway in various states and whatnot right now with continued taxing that wealth. So as we help us understand maybe the biggest misconceptions people have about estate planning when you think about addressing what we've just been talking about.
One of the biggest misconceptions is there's nothing more I can do. And there is so much more you can always do if you're just proactive. I'll give you a good example. Sometimes clients say, well, I want to leave everything to charity when I pass away. So I don't need to do any estate planning. Because if you leave your assets to charity, there's no transfer tax on it. It goes from you to the charity free of estate taxes, regardless of how much money you're leaving them. And so those individuals will say, I don't need to do any planning. Well, that's true from the federal estate tax point of view. But by doing advanced planning now, you as an individual living today with those assets can mitigate the income taxes. And you can get income taxes with your philanthropic intent if you just plan now. And so there's things you can do even for the people that are really charitably inclined right now that can help offset your income taxes if you just get proactive.
So, but I'm going to assume most people aren't giving 100% to charity. Although, but maybe from your experience, what's the range? I mean, what's your average client giving to philanthropy when they ultimately land on their final estate plan?
You'd be surprised. Um, if it is a non-taxable estate, so call it 20 million or less,
You mean non-estate tax? Is that what you're saying?
right? I would I would say probably 80% of the families really don't leave anything to charity.
So under 20, is that what you said? Under 20?
Yeah, most of it stays within their family. They leave it to their kids and their grandkids, and they're thinking about how do I let this money live on and help them live their life. Oftentimes, it's more in the more tax sensitive families that are leaving more substantial amounts to charity.
So in this example, that would be above 30 million because I'm saying 15 and 15, you got estate tax free. Right. Okay. So above that,
At a minimum, on a lot of those families, I'm seeing around 10%. And there's lots of reasons why they use the 10% number. But 10% is a pretty standard number that a lot of families use. And part of the logic behind that is, well, this money, I could either give it to my kids subject to estate tax, which means the government gets 40% of it, or I give 100% of it to charity. And oftentimes they would rather give it to charity than give it to the government.
so help us understand though the reverse engineering to the 10%. Actually, it's the first time I've heard that. Why 10% is a target?
There's a lot of religious denominations that believe that 10% is the proper amount to leave to the church, to charity, when you pass. And so that's oftentimes a motivation.
Got it. Okay, that's helpful. So if we were to kind of bring this back to California for a minute, is there some effective estate planning that would be 101 that everybody from this call should take away that they should be thinking about if they're residents of California?
Making sure you have the fundamental estate plan in place, the basic will, the basic trust, the power of attorney, your medical documents, those are your core documents. You need to make sure that you have them done, but also that they're up to date. So that's important. Secondly, is thinking about property tax planning. The property tax laws in California changed in 2021, which made it a much more difficult job to transfer real estate to your kids or your grandkids than it ever was. And a lot of people assume there's nothing I can do, but that's arguably wrong. There is a lot you can do, and you can still transfer apartments, hotels, condos, duplexes to your kids without any property tax reassessment if, again, you're proactive. Because there are ways of doing it. You just have to be proactive in accomplishing that goal. And the last thing I would say is for a lot of Californians, they have assets outside of California. They have an apartment building in Texas. They've got another property in Utah. They've got assets all over the place. Well, as a California resident, all that rental income that you're getting is subject to California tax because you live in California. But a lot of clients will set up out-of-state trusts to hold that out-of-state income. And if that trust is set up the right way, then that out-of-state income is not subject to California tax. Even though you live in California, that income can avoid California taxation if you just set up an out-of-state trust and it's done the right way.
Expanding past California just generically, without getting too much into the weeds, what are some tried and true strategies that you implement to help people think about having minimizing that estate tax by having assets grow outside of their, we'll call it taxable estate?
So the starting place is having somewhere to transfer your assets to. And the default oftentimes is, well, I've got a son, I'll send it to my son Johnny. Well, if you give it to Johnny, then Johnny owns it. It's in his own name. It's subject to his creditors, it's subject to his divorce, and you lose control of that asset. So for a lot of clients, I say, I don't know if I really like that. So the second place that they'll put it is inside an irrevocable gifting trust. And you can set up separate irrevocable gifting trusts for the kids, the grandkids, or whoever it is. And in that trust, whatever you transfer then is protected from that individual's creditors. It's protected from a divorcing spouse. And the best part is you can stay in control of that trust and the assets in that trust, which is a great thing. So tying this all back in together, the idea here isn't necessarily estate planning only works if you use all of your estate tax exemption. And if you don't use it all, then you shouldn't do it. That is absolutely the wrong way of thinking. The right way of thinking is time value of money. As a business owner, as a real estate owner, when you've bought that piece of property, you bought it at $1 million. And over time, you've had it, you've invested in it. That property, whether it's because of the ground itself or the rental incomes that you earn, that's no longer worth $1 million. Now people are offering you 10. Well, transfer taxes are owed at the time you transfer the asset, at its value at that time. So if you would have transferred that apartment building on day one when it was worth $1 million, that would only use $1 million of your exemption, or it could be even less if you use discounting. But just $1 million of your exemption. If you wait and you hold that property for the next 20 years, and now this property is worth $10 million, well, now it's going to use $10 million of your exemption. So based on that, it is way better to move your assets early on. So if you're starting a new business, start that new business in the name of an irrevocable trust. When it's valued at zero, transfer it at zero, and then let the trust be the owner of the equity and the investments and everything else that happens. That's good time value of money planning, and doesn't necessarily depend on you using all of your exemption to be efficient.
So a bit to unpack there. Love where you went, and I think we talked about valuing these assets when they get moved over, because a lot of people might invest in funds where they have no control. The funds are illiquid. So I assume those examples are ripe assets to move out of your estate because they can be, I'm not going to say devalued, but can be contributed at a lower value pursuant to illiquidity, non-control, benefiting your minimizing the amount you use of your gifting.
Right. When you make a transfer of assets, you have to report to the IRS, what did I transfer? How much of my exemption did I use? Because remember how the exemption works. Whatever you don't use during your life is available for your use at your death. So you have to track how much exemption did you use. So you value whatever you transferred, whether it's an interest in a fund, a piece of real estate, cash. Cash is easy, but you have to value that and report that to the IRS. And the valuations are based on estate and gift tax valuation principles, not necessarily the normal fair market value appraisals and valuations that we think about it in the real world. In the estate planning world, it's a little different. So sometimes we can take into account what's called lack of control, where you don't actually control the fund. You don't actually control the entity or the LLC because you only have a minority interest. Well, we can take a discount for that and discount the fair market value of what you transferred by a given percentage. And then on top of that, maybe it's not marketable. By that, I mean, if you wanted to liquidate your interest, you couldn't do it this minute or this hour or this day or this week. It takes weeks or months or years, or maybe you can't even liquidate it for 5 years. That gives us a lack of marketability discount. And when you take these discounts into account, you can discount the fair market value of what's being gifted anywhere between 20 to 40%, depending on the asset, its structure, and what's going on with it.
Helpful more to discuss, and I'm sure the question everybody wants asked is great. I've moved these assets to reduce the size of my estate, to negate or minimize the ultimate estate tax, live off your rev trust or your core assets to further reduce that valuation at death. But what happens if things didn't go well with some of the investments in my rev trust? I overgave to these irrevocable trust, and I need some of this irrevocable trust asset to sustain my life, and I misprojected that transfer. So let's talk about usage, control, and the creativity said as you can.
This is really all about having flexibility. Because as great as we design things, as great as we structure the gifting plan or the sale plan, things change. And so you need to have flexibility to adapt to those changes. So let's say you did irrevocable trust for your kid. In that situation, we would always have two main options that you could always do. One is that you could borrow money from that trust if you wanted to, and that way you would have the cash available to use as you needed. But sometimes what also happens is we gifted too good of an asset. Maybe we gifted an asset that produces too much income, that produces too much interest and dividends and other things. And you say, gosh, I wish I could have that back. Well, there's always also generally a power of substitution where you can go to the trust and say, actually, I want that asset back. Let's swap assets. I'll give you cash. Give me that investment back. And you swap, and that way you get that income producing asset back to help you live your lifestyle. And that's a very useful tool. The other thing you can also do, besides just giving assets away to your kids, which is arguably the standard estate planning tool that people have been doing for 20 and 30 years, is that there's another opportunity where you can set up a trust for your spouse and do it that way. So instead of transferring and getting assets out of your estate by gifting assets to your kids, you gift the assets into an irrevocable trust for your spouse. And then that trust is outside of your estate. But that trust can be used for your spouse's livelihood, their expenses, and other things. And that gives you indirect access to everything that's in there.
So these strategies sound like they would be ripe for IRS question or ultimate modification of the allowable rules. So how does the IRS look at these strategies that seem very advantaged for those that take advantage of them?
The IRS has these rules and these structures have been around for decades. These aren't brand new structures that I created or a single estate planning person has created. These have been around for a long period of time. And so the IRS looks at them, but they're looking at whether or not it has been abused and have you gone beyond the rules of the trust. So a good example of this is, remember that power of substitution that I just talked about? Well, the income producing asset that I want is worth $1 million, but I only have $800,000 of cash available, and I say it's close enough. Well, no, it's not close enough. It needs to be fair and adequate consideration to swap the assets. But if I just did it anyways, the IRS would say that is wrong and there's going to be consequences. So there's truth about how you administer these trusts, and that you administer the trust the right way, because if you don't get the benefits that the trust would have provided you.
How auditable and how often are these gifts to these entities looked at by the IRS while you're still living?
If you asked me that question 5 years ago, I would say often. In today's world, not as much. Right now, from what I've heard, there's only about 84 people in the IRS office working the estate and gift tax side. 84 agents, that's it. They have been severely shrunken. With that, they just don't have the time or the resources to audit a lot of returns. And so the likelihood of an audit popping up is small, um, but it could always happen.
Well, I think what I hoping our listenership understands is that there's a great opportunity to move assets out of your state, maintain some economic interest control, um, uh, we'll call it substitution rights, while those assets grow outside of your estate, minimizing the ultimate estate tax. Um, is that an accurate way to say it?
Absolutely.
So you hear often, I was just asked the other day to be someone's executor, an honor, but you need to be careful because you could be signing up for something that you're not aware of. And often you hear about things like um, the conflict that takes place with inheritance as an asset distribution and fairness and whatnot. So how can families avoid some of these pitfalls as they think about their planning and their communication and sharing and their plans with their family?
So the thing about this part of the plan is that you have to take a step back and take kind of the rose colored glasses off and say, will this create a conflict between my kids? Because remember, at the end of the day, the mother and father, the parents, aren't there anymore. So they can't act as a mediator. And so you need to really think about it from that standpoint that I can't smooth this out if something goes wrong. And so you have to think about your family dynamics and the assets involved and whether or not, if we do something irregular or if we don't do something, will there be issues? Sometimes those issues come about because someone wants the home, the primary residence. And, little Jessica really wants that house because she says, I'll never have a house like that. I want that house. But the brothers are cash poor and they say, no, we want to sell the house. I want it. Well, if you plan accordingly, maybe you can avoid a conflict. If you plan accordingly and you realize that realization, you build that into your estate plan. It's easier to think about it in regards to these money assets, like a house or jewelry, or other things like that. But sometimes conflict just happens with call it the non-financial assets. Sometimes it's about mom's pots and pans. And they say, I want mom's pots and pans. Actually, early on in my career, I had a client who actually, mom passed away. It wasn't pots and pans, it was her spoons. But it was her wooden spoons. And one of their most loving memory of mom was mom in the kitchen cooking with these wooden spoons. There were 3 spoons, but 5 kids. And so the 5 kids actually sued each other after mom died for the spoons. And it just got ugly. Um, and it was a terrible, terrible thing for this family. But it brought on a realization that sometimes the fights, it's not about the money. It's about the memory. It's about the sentiment. It's about the heart. And, they're trying to keep that alive. And so they fight for it. So being purposeful and thinking about those things in your estate plan um, can help alleviate a lot of stress and a lot of fighting. The other part to think about too is who's in control. Sometimes families will name their children and they'll go, we're just going to go oldest to youngest. Okay, well, I mean, that's one way of doing it. But you really should think about it. Is that person the right person for the job? Yes, they have a trust agreement that gives them an instruction manual of what to do, how to do it, who gets what. But there's all the other things in between, like the communication. Well, how well do they communicate with their brothers and sisters? Do they actually listen? Do they talk? Do they share information? Or is it just closed door? Or sometimes you get people who say, well, I know everything. I don't need help of a CPA. I don't need the help of a financial advisor. I'll just do it all myself. I have ChatGPT with me. In this situation, you really need people who communicate. You need people that are team players. Because if you don't, you're just setting the family up for trouble down the road. And for some families, they have individuals who can satisfy these needs and step in those situations. But if you don't, Well, sometimes the best situation is naming either a private fiduciary or a corporate trustee. Let them take the burden. Because remember, we're talking about when you pass away. And those children just lost their mom, they just lost their dad, and now their heart hurts, and now they're dealing with all the financial things that come along afterwards. Are they really in the mental place to make these decisions? Maybe yes, maybe no. But if it's a no, or maybe a no, maybe let someone else take that burden away from them, like that corporate trustee or private fiduciary.
Let's talk about that. What percentage of your sophisticated clients with um, certain net worths, what percentage use a third party trustee or executor versus one of the family members?
So I would say it's probably somewhere between 65-70% of the larger net worth families will use a corporate trustee as what I refer to as the administrative trustee. The administrative trustee is the person who, after you pass away, is the person who kind of deals with everything. They file your last income tax returns, they file your estate tax return, they get the appraisals, they divide the assets up, and then once everything's done, they distribute the assets to the beneficiaries, whether it's a charity or the kids. And once the assets go to the kids, more often than not in a trust, then you let the kids be their own trustee. So you have the corporate trustee doing the heavy lifting, all the administrative work, all the hard work. But then once it's all settled, you the assets can then go to the children and let the children then manage their own trust.
You and I have talked about legacy planning, and in your bag of experiences, I mean, what does legacy planning kind of mean beyond what I'm going to call the oversight of an investment portfolio, and how might that get melded into documents or education while you're alive and trying to pass on what's really important?
So I'm going to break legacy planning down into three components. One is in your basic estate plan or in the estate plan that you're doing, you're not leaving the assets outright to the beneficiary. You're leaving them in trust. Because you leave them outright, you are giving up all control and you're giving it to that beneficiary. Then it's that beneficiary's job to figure out what's going to happen with these assets. And then those monies are subject to the claims of creditors, they're subject to divorce, all sorts of issues. But if instead you leave it to them in trust, you get to write the rules. You write the rules for how they access that money, what benchmarks will receive certain benefits, what sort of requirements do they need to hit to be able to receive distributions. You can have a whole plan for how that happens in your own trust. And that's great. That helps protect your legacy, how you would have helped guide those individuals if you were still alive. And so it's really, really useful. So the first part is going in trust. The second part, flexibility. Flexibility comes in two forms. One is having what's known as a trust protector. We're designing this trust today based on your current facts, your current life, your current circumstances, and the assets and the tax laws and everything that's going on right now. But when we're talking about legacy, how does that play out 5 years from now, 10 years from now, 20 years from now? Maybe those rules work, maybe they don't. Think about how much our world has changed in the last 5 years since COVID. Huge, absolutely huge. In the way we conduct business and the way that we do a lot of things, the world is different. And so having a trust protector in place lets that trust stay in compliance with a changing world, because the trust protector has the power to make modifications and changes to the trust. So as the world changes, the trust can change also. And so that's a very useful tool to allow this trust to stay up to date. The second part of flexibility that we often will do is give the children who receive the inheritance what's called a testamentary power of appointment. What that allows them to do is to rewrite the rules of their trust at their death. Because you already laid out default rules for what happens when your son or your daughter or your child passes away. And maybe those default rules are perfect, but maybe they're not. Maybe a grandchild now has special needs. Maybe a grandchild has other sorts of situations and dependencies that you couldn't contemplate when you drafted the trust 30 years ago, 50 years ago. So, giving your children some flexibility to rewrite the rules of their trust at their death is a huge, huge thing when we talk about legacy planning. And when we do that, we would also generally make sure that, yes, they can rewrite the rules, but it has to stay within the family. And you can also add additional restrictions to that. That has to stay within the family, it has to stay in trust, it has to be used for education. You can put any sort of limits you want, but it allows your kids to have flexibility to deal with the changing world at their death that we couldn't predict. And the third point for legacy planning is all about thinking long term. Oftentimes, clients come and they aren't thinking long term. They're thinking 1 year, they're thinking 5 years, they're thinking 10 years. But legacy planning is so much farther than that. We're thinking 20 years. We're thinking 40 years. We're thinking 80 years, 100 years. And if you go to other states, you can plan for this trust to last over 365 years or longer, depending on what jurisdiction you go to. And so you have to really think about this trust bigger. And if you think about it that way, you can be more thoughtful in the provisions that you put in it. And so getting clients to shift their mindset to start thinking bigger makes a big difference.
What is the biggest mistake that you see families make as they think about transferring generational, any level of wealth to their next generation?
The biggest mistake is assuming that a child, it is appropriate for that child to be trustee of their own trust, and just assuming that is true. Sometimes yes, sometimes no. The beautiful thing about trusts is that it allows you to separate the beneficiary, the person who actually gets to benefit from the assets, from the trustee. And because of that, you don't have to take away assets from a child or a grandchild who is struggling or has issues. You don't have to treat them any less than any of the other children. They can still receive their share, whatever that is. But the only thing is maybe they shouldn't be their own trustee. And that's where you can think about that and have someone else in place, because you're really trying to do what's best in the best interest of that child.
I,
And having someone else in trustee might be the best situation.
I imagine the challenge there is that particular child might feel that mom and dad didn't view them as worthy to handle their own business, if you will. But again, that's, I mean, I assume the answer that you're giving, they need.
It depends on the situation. If it is, sometimes these situations aren't hidden, and it's kind of well known about the issues or the struggles that are going on. And if that case, more often than not, they can understand why it was done that way. Um, if it's a little more innocuous, that's where we'll sometimes see the private a trust company, be the trustee for everybody. And they'll say, we're just going to treat everyone equally, and we'll have the trust company be the trustee for all. Just because we don't want to treat any of our kids differently, we'll have them just corporate trustees.
Anson, when do you start talking to your adult children about your estate and planning?
I think the most important part about the planning is giving your children confidence that you've done an estate plan, that you've thought about it, that you've done it, that it's up to date. And if something were to ever happen to you, this is where you find it. I think that is the most important part. And then maybe even telling them there's medical documents for medical issues, there's other documents for in control. If you have questions, contact the attorney, contact the CPA, contact the advisor. I think that's the most important part. In my mind, especially if you're dealing with younger beneficiaries, I would be conservative and not necessarily tell them everything. You don't necessarily need to tell them the hierarchy of the trustees, that it's going to go from John to Sam to Dave. You could, but the hard part, and why I bring this up, is sure, you had the meeting with the family and you said the trustees were going to be John, Sam, Dave. And then you and John have a falling out. You guys get in a terrible fight about something. And you say, oh, I don't think I can trust John anymore. I'm going to change it. And so you call your attorney, you amend your estate plan to change trustees to no longer be John, Sam, Dave. Now it's Sam, Dave, John. Well, did you call John and tell John, John, I took you out as the successor trustee of our trust. Now it's going to be Sam. Most families don't do that. They're not looking to have that argument and that conversation with their child when they change their mind. But what you've done is you have planted a seed in John where he's anticipating, I'm going to be the trustee of that trust. Mom and dad sat me down, we sat us all down, and that's what he said. And then all of a sudden, when you pass away, some new document magically pops up and he's no longer trustee. Now he thinks something fishy happened, that something scrupulous happened, that this was never mom and dad's intent. Sam must have done something wrong, and it creates conflict. So every family is different, but generally, I think the general way of approaching this is be conservative on how much you tell your kids to protect your ability to change your mind. That's the key.
That doesn't mean you don't educate them about asset profiles and how investments work, with the understanding that, there's going to be some of that transferred at some point in the future.
Well, you absolutely should be doing that, because you really need to think about your wealth almost as a business. And when that business, your wealth, transfers from you to the next generation, how is that wealth going to be preserved? That wealth only is preserved if they're educated and they know what to do and how to think about it. And this goes down to your legacy idea about legacy planning. There's one other part that I didn't really mention, and it's something really powerful in doing legacy planning, is the non-legal part. Sometimes clients will leave what's called a letter of wish, where the clients will leave a non-legal letter to their family that says, this is how I built my wealth, this is how I invest, this is my methodology, this is my methodology for the estate plan, and how I think you should use this estate plan in the future, and just kind of share your own thoughts and feelings, and let those thoughts and feelings go from generation to generation to generation. Now, it doesn't have any legal standing, but it's called a letter of wish.
Anson, we're going to have to move towards our closure here, but I do want to ask, as you were talking, the other question I had for you. You're hearing about people, they live a lot longer today. So, Mary and Steve get into their mid 90s, and Mary lasts till 99. And oh my gosh, their kids now are in their 70s. And at that time, to get some transfer is all well and good. But it's not going to change or affect their life. So you're hearing a lot about people moving assets while they're still alive. And how is that manifesting that in documentation or these conversations we have? And is that a reality that you're seeing?
Absolutely. Absolutely. There is also a balance that we're working with here. And the balance is, by gifting assets, you're getting that asset out of your estate. So there's no estate taxes on it when you pass away. And you can do it into a generation skipping transfer dynasty trust, which is all wonderful. But the counter of that is that if you gift the asset out of your estate, there's no basis adjustment in that asset at your death. And so it is a counter of the two. If you avoid the estate taxes at your death, that is great. You avoided a 40% tax that would have been owed 9 months after you pass away. Wonderful. But that individual received your carryover basis. They carried over your basis in the asset to them, and now they're going to be saddled with an income tax recognition event at some point in the future. Granted, they get to control when that income tax recognition generally happens, which is a better situation than after you pass away. But that is a realization. So when you're talking about those 90-year-olds, those 99-year-olds, those older individuals, is it best for them to start gifting their assets away now? Maybe not.
At 99, I'll agree with you. Yes.
Because if they pass away owning the asset, then the basis in the asset adjusts to that asset's then fair market value. So you can sell the asset and diversify. You can no longer have to 1031 exchange anymore. There's a lot of things you can then do.
Well, the best half step is I think you can gift up to $19,000 per person that you give it to. So your wife and you could give $38,000 to 10 people if you choose, without it affecting your gift estate trigger that you got to include.
Yeah, that's the de minimis amount where the IRS says, we understand you're going to be out there doing things for other individuals. We don't want you to have to keep track of every little thing that you do. And so we'll let you do a de minimis amount without having to use any of your exemption and without having to tell the IRS. That's what's generally referred to as the annual exclusion amount, which is at $19,000 each. So what a lot of clients will do, combining this with that time value of money concept that I mentioned, they'll set up irrevocable trusts for their kids, and the husband and wife will transfer $38,000 a year into that trust, or into each trust for each of their kids. And every year they're squirreling away $38,000 into that trust. And it's a trust that's protected from creditors. It's protected from divorce. It's a trust that they still control, but that time value of money now becomes more powerful because you're putting away $38,000 every single year. And as that grows, all that appreciation growth is also outside of the estate.
Anson, we're going to absolutely have to have you back because we touched upon many things. But if you were to wrap your remarks and our conversation today with what I would call just an action item for our audience to think about in a way that is not overwhelming, because I'm sure a lot of them said, this is exactly why I'm not doing this, because it's too complex and I don't want to track it, understand it. I'm just going to keep it simple, stupid. But what's the counter to that, and how might you call them into action?
So we talked about a lot of topics today, and that's where some of the complexity happens because we went in a lot of different directions. However, normally when you meet with an estate planning attorney, it is much more focused, is much more driven, it is much more down the line, easy way for you to understand. And so what I would encourage anyone to do is, as I mentioned a couple times on this call, be proactive. Be proactive by sitting down with your estate planning attorney, reviewing what your assets are, what your wishes are, and making sure first your core documents are what you thought they should be. And then from there, you can always say, are there any income tax planning strategies or estate tax planning strategies that might help me or my family? And that's where you can start diving into other alternatives and going one by one and seeing what fits your situation.
You're a steady hand. You're an educator. I've enjoyed our relationship and will continue to enjoy it. I think our audience got many takeaways from the legacy planning models and categories to just the letter of wish that you suggest is a topping off and a real helpful tool for communicating, kind of that maybe a document can't as easily communicate some of your real wishes. So I can't thank you enough. We'll have you back, and I'm sure people will be reaching out as maybe you've prompted them to think about their own situation. So thank you for that.
Thank you for having me, Robert. It was an absolute joy. It's always nice talking with you.
We've had some good learning today. Appreciate you all listening in, and we'll look forward to our next episode together. Thank you very much.
Thank you for joining us on this episode of the Counting Capital Podcast. For informational purposes only, and not to be relied on in any manner as legal, business, financial, tax, or investment advice. Nothing in this episode is an offer to sell or the solicitation of an offer to buy securities. To learn more about Buchanan Street Partners, please visit our website at buchananstreet.com. Buchanan Street Partners, capital you can count on.